Good morning. My name is Howard Henderson. I am professor of justice administration, but also director of the Center for Justice Research at Texas Southern University in Houston. And somehow they've chosen a criminologist to moderate a panel with two legal experts, so we'll make sure we say the right thing. This morning, this conversation that we'll have will be about the unintended consequences of the Daubert decision. The Daubert standard was intended to ensure expert testimony was admitted in federal court and scientifically valid and reliable when the Supreme Court decided this case in 1993. However, its application over the past 30 years has had various unintended consequences beyond the original intent. This panel will foster a discussion on where Daubert's implementation has diverged from expectations and how application can be improved. This morning, I have the honor of moderating this panel. Let me first introduce Professor Ronald Allen of Northwestern University. Professor Allen is a renowned John Henry Wigmore Professor of Law at Northwestern University. He is one of the most highly cited evidence scholars, and get this, he's an expert on expert testimony standards. Imagine that, having authored leading texts in the field. Also joining our conversation is Professor Andrew Jurs of Drake University Law School. Professor Jurs has authored multiple scholarly works examining Daubert's impacts on judicial gatekeeping and access to courts. Each panelist will have 15 minutes or so as an opening statement, followed by a moderated discussion as we've just seen the previous panels. Again, join me in welcoming Professor Jurs and Professor Allen to the conversation. Thank you.
Thank you for that introduction. It's a pleasure to be here at such a distinguished gathering, and I have only 15 minutes, so I'm going to jump to the chase. I'm a legal analyst. Most of you in here don't know who I am. I'm a legal analyst whose work focuses on the structure and foundations of the American legal system. This is a positive, not a normative inquiry. As Jennifer noted, 3 decades ago, I became intrigued by the problem of expert testimony. The diagnosis that emerged was threefold. First, the cause of the problem. Second, the limits of the proffered solutions. And third, what might be done about it. The central problem, as has been discussed and alluded to, but I want to be direct about it, is the informational vulnerability of the law. It's obvious that there are knowledge-based disciplines in the real world, the knowledge of which may be crucial to increase the probability of accurate outcomes at trial, but the legal system does not possess that knowledge. That is a problem, and that is the problem. So what to do? Often when faced with a tricky substantive issue, American law searches for a procedural solution to that substantive problem. That's what a trial is. The law personified knows not who is telling the truth, so it sets up a procedural mechanism that gives a good chance of getting the right answer. This is exactly what the first recorded case of expert testimony did in 1554, Buckley versus Rice-Thomas, where the court noted that when faced with difficult questions of specialized knowledge, the thing to do was ask the gentleman, the erudite gentleman, distinguished in a pertinent field for their advice, and then to defer to it. That solves that, and continue to solve the problem up to the latter part of the 20th century. Although the Frye test had dominated in the United States until Daubert, and actually in some ways may still dominate in the States in interesting ways, no longer searches out the erudite gentleman. It nonetheless embraced the notion that the legal system should reach out to whoever has superior knowledge and again defer. That is the general acceptance test of Frye. We no longer consulted our own knowledge about the erudite gentleman, but instead identified a discipline and see what the consensus in that field is. That worked fine until these erudite people in various disciplines began to disagree with each other. And now what? The legal system continued in its deferential path by concluding that think about this, diametrically opposed opinions were both generally accepted within a field, and that the opposing experts could testify to opposite conclusions. Quite bizarre if you think about it. But what's the fact finder supposed to do once that happens? By hypothesis, the fact finder does not possess the specialized knowledge to decide the problem, but that means it lacks the ability to choose rationally over the opposing expert. The point that's again been alluded to today, but I think needs to be made clear. You're asking them to make a judgment that you know they cannot make. So it cannot be rational. It may not be irrational, maybe irrational, but it guarantees one or the other. That's what led to Daubert. It should not have taken to 1993 to see this problem. Trials are pedagogical events, the deepest aspiration for which, I think, check your own intuitions, is to have disinterested, unbiased, intelligent fact finders hear, process, and deliberate on evidence until a consensus emerges as to what happened. The conditions that ex ante, you don't know who should win, seem most likely to generate accurate outcomes. The parties disagree as to what lessons should be learned, to be sure, but there's a rational path to an outcome to resolve that disagreement. When experts provide opinions which cannot be understood in that fashion, the only choice is deference, which is the opposite of this steep educational aspiration for trials. In my opinion, the ways in which expert testimony can be used, it doesn't have to be used in this way, but as we're talking about, it is a reproach to a civilized system of trials. Daubert recognized some of this, but stopped short. Rather than just defer to purported experts, trial judges have to become educated enough in the pertinent field rationally to conclude that the proposed testimony is reliable, using that term in the legal sense, not the empirical sense, which has a different meaning. That was a huge step forward, but Daubert's failure was to require that the evidence be presented to the fact finder in a way that it can be understood. To educate the fact finders, in other words, like the judge had to be. Some doubt that this is possible. I think that's wrong. The question is not whether each juror understands the basis of the testimony. It's whether the jury reasonably has enough information to make an intelligent decision. Jennifer early today used the phrase full epistemic competence. We had a conversation afterwards about this. That's not the standard. The standard isn't whether somebody is the leading figure in a field. The issue is whether they have enough to hopefully make a rational decision. And small groups, and again, it's not a juror, it's jury, and small groups have enormous cognitive capacities. I see my colleague Sherry Diamond is here. Maybe she'll talk a little bit about this. I hope she does. But suppose that's wrong, as some people have been alluding to today. Suppose it's wrong, that you can't educate these people. Then it is utter madness to use this form of dispute resolution with its guarantee of irrationality. It's like flipping coins to resolve debates, to resolve cases. I have one more substantive point to make, but just as an aside, this interest of mine in expert testimony is not, I'm not interested particularly in scientific evidence. My research program has to do with naturalized epistemology and its implications for legal systems generally. This was sort of an aside, not an aside, a component in that process. And so I have not really contributed to this field over these last years, but I remain completely puzzled by the nature of the discourse. Think about what we've heard about today. What you see is a continuation of this search for a procedural solution to a substantive problem. It works with trials because the people who you've set up as triers of fact do have the competency to hear evidence, to process it, and deliberate on it in a rational way. But if you actually don't think that they do, it's nuts, it's crazy to resolve disputes in this fashion. Now, there are a lot of other ways you can resolve it. We can talk about that later. But let me say this. I think the problem is largely one of the legal system's own making and can be resolved or not by it. However, just to be clear, the federal rules of evidence do not solve, but instead exacerbate this problem by actually encouraging deference in various ways. But last point, probably a little controversial. I'm not going to let you scientists off the hook entirely. There's a distressing phenomenon, increasingly distressing in my opinion, of individuals in various disciplines letting their pecuniary interests, like experts hired to say things at trial, or their political biases adversely affect their scientific contributions and how those scientific advances are presented to the either jurors or citizenry. Rather than acknowledge the contingent nature of disciplines, omniscience is claimed. I think that these claims and the failure of responsible people working in the various disciplines to point out the limits of knowledge in response are proving counterproductive and bringing the entire knowledge industry into disrepute. Claims of omniscience invariably dissolve, and we see it in all kinds of different areas in life and in the court system and so on. Couple that with the increasing stories coming out about how scientists have to tailor their work in order to meet the politically correct attitudes of editors. The most recent example being Patrick Brown's expose of what happened with his article about climate change. And when there's not a storm of criticism from the rest of you in the field, I think, and that's an empirical question, and I don't have data, but what concerns me is the experts begin to look in the public eye as no different from those compounding the absurd anti-vaccination arguments or various conspiracy theories. No one can be trusted. That is a problem. Now, why does this matter? For me now, from a legal analyst point of view, it matters to me because the population at large isn't stupid. The behavior of omniscient experts that make claims not to advance their discipline, but to pursue their personal interests, may, and I have to say it's an empirical question, may inculcate skepticism in the public at large, leading to a citizenry more likely to resist rational edification than would otherwise be the case. I think this is a serious problem. It's a big, big problem in my opinion, especially for efforts to resolve dispute resolution in a rational fashion. So we should be in this together. You continue your admirable, really amazing efforts to further human understanding, including recognizing its limits, and hopefully those in the legal system like me will work to create conditions under which what we know, what we think we know, and what is ambiguous can be provided in fact finders in comprehensible ways. This is the only way that we can advance this deep aspiration of an educational process that gets the facts right. And why does this matter so much? The last idea I'll leave you with, why is this such a deep aspiration? If I were to ask an intelligent group like you what characterizes our way of life, maybe what allows us to thrive, you would, I think, almost to a person immediately start thinking about rights. Bill of Rights, Magna Carta, you might get fancy and talk about the Code of Hammurabi, human rights, the whole 9 yards. There's a lot of truth to that. Every single conception of a right that you can come up with, and I have done work across the entire world, China, Tanzania, Australia came up, every single conception of a right is utterly, utterly dependent on facts. If you do not get the facts right, that right becomes meaningless. So I will leave you just with that idea that facts are as, if not more important than rights. Thank you very much for listening.
Good morning, everyone. I'm in the unenviable position of being in between you and lunch, so I'll try to keep it brief and engaging. I want to thank the association for the invitation to join you today to talk about one of my favorite topics and the subject of a lot of my work, the unintended consequences of Daubert. Ron and others have written extensively on the issues of the underlying problems of the structure of the Daubert standard, and we can see a lot of the weaknesses of those assumptions. But my co-author and I, my co-author Scott DeVito, we approach the question from a different perspective, which is to look at this from an empirical standpoint and ask, what was the true effect of Daubert in 1993? And when we look at those questions, we find some counterintuitive and surprising findings, and I'm going to share two of those with you today. First, I'm going to talk about the true effect of Daubert after its adoption in 93, and then we'll talk about the potential for discriminatory effects of the Daubert standard as well towards the end. And so the first question we were going to address when Scott and I started looking was, can we even measure the effect of Daubert on scientific reliability screening? And if so, what is that effect? Now, for the non-lawyers in the room, I want to take a brief diversion, and that's because I just want to talk about the case itself. And Daubert in 1993 decided that the previous standard from Frye, which required general acceptance, would be thrown out, and it was rejected because of an incompatibility with the so-called liberal thrust of the rules, and the court concluded about the Frye standard that austere standard, absent from and incompatible with the federal rules of evidence, should not be applied in federal trials. 4 years later, in General Electric versus Joyner, the court underscored what it thought it was doing by saying that the Daubert standard means that the federal rules should allow district courts to admit a somewhat broader range of scientific testimony than would be admissible under Frye. And our question simply became, is that actually true? Now, Professor Munkin mentioned earlier that there's a lot of research on this, and we found it to be largely inconclusive. There had been survey works that had been done. There were published case studies that had been done. Some showed no effect, some showed a stricter standard. And so we wanted to find out for ourselves, and here's how we did it. We collected an enormous amount of data on state and federal case filings. We decided to use a metric to measure the management of cases by litigants, and then we wanted to measure how the metric would change in response to Daubert, and we did this in a series of studies. The first one dealt with civil defendants, and of course we needed a metric to think about how to measure their change or their reaction to Daubert, and the metric we chose was removal rate, which is something that Ed Cheng and Albert Yoon had first used back in 2005. Again, a quick diversion for non-lawyers. When a civil defendant is served with a complaint in state court, if they meet the standards for diversity jurisdiction, they can remove the case to federal court within 30 days. Now, like all diversity jurisdiction cases, if a case is removed, the federal court will apply state substantive law for continuity standards, but federal procedural law. And Daubert is considered to be procedural in nature, and so if you are in a state court that has the Frye standard and you remove to a federal court with the Daubert standard, you have now changed the gatekeeping standard that will apply to your case. And we wanted to see, did the number of removals change after the Daubert decision? So we used a thought experiment, and we'd ask, what would you expect to see if Daubert was stricter? And what we thought was we'd expect to see that there would actually be more removals, like the graph here. Now, the scale on the left doesn't matter as much as the overall line, which shows that if Daubert's adopted, you would expect to see a jump in the number of removals so that the defendants would have the plaintiff's experts subjected to that more strict standard. And when we collected the data, we collected 3.5 million cases filed between 1990 and 2000. We ran it using a difference in difference statistical approach, and actually the result matched this. We found that, in fact, civil defendants do leave Frye State Court more often than they did after the Daubert decision in '93. There's actually a natural way to double-check this result, because after '93, state courts can decide to adopt Daubert as their own state standard. And if they do that, the benefit of changing from state to federal court now disappears because they'd both be applying the same standard. And so we thought, what would you expect to see in that result? Well, you'd expect to see that the initial bump from the Daubert decision would be mitigated, and you'd expect to see a decline. And when we ran the data here, we found the exact same result, that in fact, the defendants will lower the amount of removals in response to state adoption of Daubert after 1993. And so we concluded in this first study that civil defendants are acting in ways that show that they believe Daubert is a stricter standard than the alternative Frye standard for general acceptance. Now, a second study analyzed the effect of Daubert on civil plaintiffs, and we wanted to see if they also acted in similar ways. But of course, we couldn't use the removal rate any longer as the metric because the removal is a defendant's decision. And so instead, we looked at the initial filing decision, state versus federal court, and the plaintiffs have the ability to file sometimes in one or the other and choose their venue. And we just wanted to measure the filing ratio, which would be the number of federal cases compared to the number of state cases. And again, we used a thought experiment. What would you expect to see under these circumstances if Daubert was in fact stricter? And what we hypothesized was that after Daubert was adopted in federal courts in '93, you'd see a decline in federal filings and more filings in state court because the plaintiffs want to be in the venue where the gatekeeping standard is a lower standard against their experts. Now, when we compared the data, we ran it again using a difference in difference statistical analysis, and the result was actually the same, that in fact, after federal adoption of Daubert, civil plaintiffs were filing in state venues more often and less often in federal venues. As with the first experiment, there's a way to double check this result using the adoption of Daubert in state courts after '93 to see what the reaction would be. Again, this removes the benefit of changing the venue, so the gatekeeping standard would be the same. And we did a thought experiment thinking that you would expect to see a rebound effect in which the number of federal filings would increase because there's no longer an incentive or greater incentive to be in state court. We ran the data here, and we found that in fact plaintiffs were behaving this way, that after the state adoption of Daubert, you will see an increase in federal filings. Our conclusion in the second study was that civil plaintiffs also act in ways that demonstrate that they believe Daubert is a stricter standard, which leads to our counterintuitive finding number 1 of 2. We believe that Daubert, while intended to be a lesser standard by the language of the court, actually has the opposite effect. The case management decisions of both civil plaintiffs and civil defendants in real cases demonstrate that they believe Daubert is stricter than the alternative Frye standard. This led to a second question. We looked at the effect of Daubert overall, but then we started to think about these larger trends and whether they might mask any varied effects on different groups of claimants, such as women or community of color. This is a finding from the tort reform literature that indicates that there's discriminatory or disproportionate impacts of tort reform upon different groups. And we thought, let's take a look at Daubert and see if it has that effect as well. And so quickly, I want to make a quick diversion, which is to mention that researchers have identified that the area of discriminatory effects in the tort system is an area that has been under-examined. Eric Helland noted that it was odd that so little attention had been paid to the role of race and poverty in the American tort system. Jonathan Carty said, existing scholarship only scratches the surface of this important topic. And Ronan Abraham said that the lack of attention to race and gender discrimination in tort law and civil justice in general is a, quote, great embarrassment and a problem that can no longer be ignored. And so we felt the need to examine this issue, again, building out of some work we had done in the area of tort reform and some findings from others in that area. And what we did was we took the data from our first study, 3.5 million cases filed between 1990 and 2000, and we actually combined it with census data, which tells you the demographics of every county in the United States. And in the data, you can find the county of origin for each case that's filed. And so you can match the cases that are actually filed to the location where they're filed, including the demographic of that location. And you convert it ultimately into a filing rate, which is filings per 1,000 residents. Now, I don't want to get bogged down in the weeds here, but overall, we're looking for a metric, and we found one, which is the filing rate, which is connected to the demographics of each location. And we would analyze that effect using a fixed effects model, which could control for various other factors that might be relevant to this analysis, including one which was poverty, because we were concerned about the economic impact of associations between different groups. And we took this metric and we examined the effect of the adoption of Daubert in 1993, and what would you expect to see if Daubert is stricter? Now remember, a moment ago when we did the plaintiffs' study, we saw that in fact there was a drop in 1993 in which plaintiffs would be more likely to file in state court than in federal court after that decision to take advantage of the Frye gatekeeping standard. And so we hypothesized that in fact you would see a drop overall in all these different demographic groups. Instead, what we saw was an effect that was different. In reaction to the federal adoption of Daubert, we saw a split analysis in which the filing rate drops much more significantly in counties that have a higher percentage of African American residents, and in fact, locations with a lower rate of African American residents with a higher percentage of white residents, you might not see a drop at all. In fact, in some places, you might see an increase in filing. And that certainly was extremely counterintuitive for us. Again, there's a way to double check this result by looking at the issue of the reaction to the state adoption of Daubert after 1993. And so remember, when we first looked at this in the second study, we saw that in reaction to the state adoption of Daubert, you saw an overall increase in the number of filings in federal court, because now there's no difference between the two venues, and so there's no artificial reason to be in the state venue. And so we expected that you would also see a rebound effect where an increase in filings in federal court would happen. And again, we saw a result that was different than what we expected. This time what we saw was that when you have the state court adopt Daubert, in fact, there is not a rebound effect at all, that the filing rate in counties that are more, have a higher percentage of African American residents stay down, and the filing rate in counties with a higher percentage of white residents stay higher than before. And so this leads to our counterintuitive finding number 2, which was adoption of Daubert had a different effect on communities of color, negatively affecting the filing rates disproportionately to communities with more white residents. And again, as I mentioned at the start of this conversation about this demographic study, this acts a lot like tort reform does, which has demonstrated disproportionate or discriminatory effects as well. You might be thinking, why is that? What could explain these results? And we had the same intuition, which was there must be something in effect. What could that be? And first, we thought about the literature in the tort reform area, in which the thought is that tort reform, once adopted, causes law firms, particularly plaintiffs' firms, to retool their overall business model, to perhaps go into a different area or try to develop a different base of cases than they might otherwise have. And so once you do that, it's hard to retool it back. And so we thought maybe once they make the change initially in 1993, that they're unlikely to have a rebound effect. And then secondly, we also thought about claim valuation and likelihood of success, and that there are cases that are on the likelihood of guaranteed victory to guaranteed loss. In the middle, there's going to be some that are marginally yes or marginally no. And we thought it might be affecting those cases that previously were marginally yes file cases and knock them into the marginally no don't file category as well. We clearly thought this was an area that needs significant additional study, and we're going to be looking into that in future work. Although we did say that there needs to be a cautionary principle here, that when judges are adopting significant procedural changes in the law, it's not unreasonable to think that they think about the overall effect and potential discriminatory effects of those changes. I'm proud to say that Justice Watts of the Maryland Court of Appeals found that to be a persuasive argument, and she used this study as one of the foundations for her argument in the decision Roshine versus Stevenson in 2020, arguing that before the state of Maryland adopted Daubert, they should examine the potential discriminatory impacts of that adoption before doing so. Unfortunately, I'm sad to report that that was a dissenting opinion, not a majority, in a 4-3 decision. And so overall, Daubert was intended to be a relaxation of the more austere Frye general acceptance standard that had been used previously. It's been seen as a neutral procedural rule of admission ever since, and the work that Scott and I have done show that neither of those is in fact true. Thank you.
Floor to discussion.
Can I ask a question?
Yeah, please.
I take it you ran regressions. Did you sort out poverty as a variable?
Yes, in the second study about the disproportionate impacts on communities of color, we did use control of poverty, although the census data we used was not discriminating enough to deal with non-poverty economic differences. And so that was one of the weaknesses in the study that we identified in the study itself, which is why I think this is something that merits significant additional attention. Thank you for the clarification, though.
Yes, sir, go ahead.
We do have a question from online for Dr. Jurs. You specifically mentioned black people in your studies, but research has shown that Native Americans and Hispanic people are also overrepresented in carceral system. To what extent does this research on minorities extend to all minorities? Have you looked at other groups, such as women?
That's an excellent question, and this is the first of hopefully many studies in the area. The data that in an empirical study, you're limited by the data that you're working with, and we wanted to run the data based on African American and white residents first as an initial way to delve into this to see if there was a disproportionate impact. We did not do so based on gender or other differences. That would be an interesting study, something that's certainly warranted, and hypothesizing, I would expect to see similar results from other groups, only because you see those similar results in the area of tort reform. And so since we found a similar effect from tort reform with African American filing rates, I would expect to see similar results for women and other communities of color.
Yes, ma'am, go ahead.
This is a very interesting conference to hear such intelligent, careful research about law along with discussions of research. So I'm probably wandering into something, well, I'll just admit, uninformedly, but I wonder about your data and the extent to which some of the science is so biased that when you have different standards of admissibility and there's the ability to come in with weaker science, that for marginalized or discriminated populations, women and people of color, that is having an impact on your data.
That's interesting. I would expect that that would be a greater impact in the criminal system rather than the civil system, but certainly there's no reason to think that it's only a criminal justice issue. But a lot of the forensic sciences that have been mentioned earlier, bite marks, hair, various other tire tread analysis, things of that nature, those were initially admissible because of the long-standing admissibility in previous cases, and so I think there was a relative lax approach to them. Unfortunately, as Chancellor Minkin mentioned, there hasn't been a lot of movement away from that from the judicial system, that it's been largely the communities themselves of scientists who have moved away from those different areas. So I hope I answered your question.
You did. So whenever anybody talks about the civil system, for someone like me, I'm in the civil system around issues of interpersonal violence in schools and families. And so it's not about, causes of fires.
These are tort cases that we were working with. So a lot of it would be causation, but obviously the gatekeeping effect has a wide variety of effects in different areas. So I'm not as familiar in yours.
And while you're coming up, I'll ask a question of Professor Allen. Are there any remedies to this?
Well, yeah. Don't try cases if you actually think the person deciding the case can't understand what the case is all about. Now, there are a lot of ways to resolve that. It's not in the American tradition, but you can resolve these complicated cases through legislation, like Congress tried to do with the asbestos. Didn't succeed, but tried. Somebody was talking about the Australian method of what's called hot tubbing. I don't know, is Neil, you a professor from Iowa State, are you still in the audience? Did you look into hot tubbing? I think that's really intriguing, actually. Hot tubbing gets the experts together, and they can critique each other. Now, what does that mean? That means you're going to go down the rabbit hole of education and figure out where they actually disagree and why. At least it opens up that as a possibility, right? But as I say, I find it just puzzling. We keep searching for this procedural solution, but it is a substantive problem. It's knowledge-based, and you can talk all you like around the problem, but we should maybe start talking about the problem.
Thank you. Let's take the next question.
Thanks. Andrew, just to clarify, do you think that the rates of filing differences that you see between different racial demographics are driven by plaintiffs themselves or potential plaintiffs, or by the attorneys making decisions about who to serve?
It's an excellent question. I don't know. Certainly, the underlying mechanism of the result we found is something that we were hypothesizing about at the end of the piece, and I offered some of the suggested potential explanations. I think our explanations generally would tell you that it's the plaintiff's attorneys themselves who are making the choice not to file certain cases, but I don't think that the alternative explanation is something that should be excluded. It's certainly possible that it's a discriminatory decision on their part not to serve certain communities, but you would hope that wouldn't be the case. But I'd like to find out.
I'll ask one more question of each of you, actually, and I'll take the privilege of moderating. Some argue that Daubert has unfairly disadvantaged plaintiffs by treating defense evidence differently. Do you think this is a fair criticism?
Well, there's another curiosity about these conversations about expert testimony or expert evidence. We act as though there's a unified system. There isn't. There are two different systems. What happens in civil cases is just entirely different from what happens in criminal cases. In civil cases, the implication that you're asking about comes from the fact that Daubert can require greater resources. Defendants, I think the set of cases you're talking about, defendants tend to have greater resources. That's changing now. I mean, that used to be the case, but now they're with so much money at stake in mass torts and with litigation financing and the like. This is changing, but I think that's the phenomenon that you're seeing. A small single attorney law firm could file a suit and under Frye and maybe get the local expert in, and under Daubert, all of a sudden you're dealing with Daubert hearings. And Daubert hearings, we were talking about education before. Again, this is not my main field, but because of what I do and this stuff that I did, I've been involved in a lot of consulting with mass torts in particular. These judges are good. These are federal judges. This idea that they can't be educated if they put their mind to it is just false. Now remember, the issue isn't can you turn a judge into the world's leading expert in infectious diseases. That's not the question. The question is, can you communicate enough information so that that person can understand the nature of the problem and then dig into it himself or herself? So I'm sorry, I'm kind of doing a riff on your question. Right, but so I think there is a difference, but in criminal cases, I don't know if our judge is still here, she won't admit to this, but the judges in criminal cases are afraid of the compulsory process clause with respect to defendants offering evidence. So they admit just about anything that defendants want to have admitted. Well, having done that, the prosecutors are now behind the 8 ball. And so to offset this liberal, in fact, tendency in criminal cases for criminal defendants, they admit just about anything that the state wants to offer. It's really quite shocking if you read the cases about what kind of material is admitted. The dog case is a good example. Language, gang language, including sign language, drug systems, how they operate. It's just amazing. And these are all just mainly police officers and FBI agents who say, based on my experience, yada, 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 and it all comes in. I mean, all is a bit of an overstatement, but basically all comes in. But then you offset it, and the plaintiff, the state brings in the dog. Okay.
Do you have a dog? No, go ahead.
Yeah. It seems to me that if you're looking for the issue of the plaintiffs being disproportionately disadvantaged, it lies in the burden of proof that the judges are looking at potentially shaky evidence that might meet the strict language of Daubert and saying, yeah, but nobody's going to buy it. And they're making a decision of sufficiency. Now, Ron and I were just talking about this before the panel, about how maybe there's some admissibility sufficiency blending going on. And we would like to look at that issue because it's curious to see how many judges would be making some sort of sufficiency-based argument when this is supposed to be solely about admissibility alone. I tried to study that earlier in a judicial survey about 10 years ago, and unfortunately the questions that I asked were not sufficient to be able to find a conclusive answer, but I'm still looking at it.
Just to pick up on that, if you're a trial judge and you have these relatively low standards for admissibility, but you think, if I admit this, and even though I think that case should lose, therefore I'm going to have to enter a directed verdict, or JNOV, what are you going to do? You're going to use a sufficiency standard to test the admissibility question. And I think you actually see that out there in civil cases. Now, criminal cases, again, why these are such different worlds, you don't have that question, because the judge is not going to direct a verdict against a defendant in a criminal case. It's a completely different world.
Well, listen, we appreciate the great discussion. If Daubert was a human being we can talk to, it'd be much easier to deal with, right? But, we need these kinds of conversations to happen, because the assumption is that there are no unintended consequences, but the reality is there are. So we appreciate you bringing your expertise to the conversation. We thank you for sitting here before lunch, listening to this, and providing your feedback, and we look forward to next sessions. Thank you so much.